while Juan is checking that, let me welcome you all and talk to you a little bit about what we're going to be doing for the next couple of months. First of all, you're all already into your bar prep classes, and so you're already having fun. And by the time we get to February, you're really going to be having a lot of fun. As you well know, come on in, Danny, it's a tough road. What we're going to do in these supplemental classes, it's a mixed bag. We're going to do a little bit of this, a little bit of that, all of the time trying to supplement what you're getting in your commercial courses, not replace it, not duplicate it as much as possible. So we're going to focus today primarily on MBE multiple choice questions. I'm going to talk a little bit about exam writing, essay writing as well. And then as we move forward, we're going to have sessions that do a lot of different things. We're meeting once a week approximately with a few variations to try to get everything in. I have, as much as possible, tried to arrange these classes so they don't conflict with your commercial courses. And if a conflict comes up, then let me know. We don't have a lot of room to move these classes around because of the heavy commercial schedule. Plus, you all know, because you just graduated, that rooms are tough to get here at STU Law. So we'll do the best we can, though, to accommodate if there are some changes in your commercial schedule. Before we jump into the substance for today, a couple of little sort of housekeeping things. First of all, food, very important. And you'll have in your packet the February bar exam lunch sheet. Please fill it out at your earliest convenience. You can turn it into me here at this session. You can always turn it in upstairs in my office, or you can give it directly to Career Services. Career Services has a lunch for you on the Tuesday and the Wednesday of the bar exam. And might not seem like it's a big deal, but it is, because you're going to come out from the morning session. You will be hungry. You're not going to want to have to go any place to get food. You are in downtown Tampa, and you could walk outside and get food, but I can assure you that's a whole lot easier to have the food there for you. And the menu at the bottom, it's not exactly 5-star, but it is food that's good for the bar exam. Peanut butter, tuna salad, garden veggie wrap. These are things that will sustain you in the afternoon session. While you want to make sure you eat a good meal, what you don't want to do is overeat. If you overeat, you're going to sleep through the afternoon. So we have, again, we've very carefully chosen the food there. Take advantage of it. And you'll be glad that you filled that form out. So that's form number 1. Number 2 is the schedule. It is fairly well set, but it is possibly tentative. We've already had to make a couple of switches, move things around to accommodate lecturers and other things that come up. So follow along. If there are any changes, we will let you know. And just so that you have a heads up, next Friday, Professor Martin is going to be doing her commercial law lecture. Would highly recommend that you attend that lecture, particularly if, as is probably the case with many of you, you did not take her commercial law survey, and so you don't know anything about Articles 3 and 9. These are new topics that the examiners added effective last February, and of course they tested Article 9 in July. So it's certainly possible that you will have a component of commercial law on the Florida portion of the exam, probably the essay portion. So I would encourage you to attend next Friday. Now, I have something I have to do Friday afternoon, so I'm not going to be in the house physically. I'm going to be here in the morning on Friday, but not in the afternoon. However, Amar is going to come in case there are any questions and sort of host the event, if you will. And we'll always have somebody who's available. Many of you have worked with Amar already, so he'll be there to answer any kind of questions that I would normally answer. Any questions about the schedule at this point for these classes? Okay, so let's get to the really, really important point of this session, and everybody gets out the notes and starts to write. No, 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 no. It's your little raffle ticket. So what I'm going to ask you to do now, and we will do every class, and remember, this is the February exam. It's a relatively small group. Every class, we will do a raffle drawing about halfway through, and the winner gets one hotel night over in Tampa during the bar exam. So it's a good deal. Fill out your little form, and we'll do a drawing, again, as I said, about halfway through the lecture today. You get just one hotel room. So if you win today, you don't get to get another hotel room. But we have in the past had some people who were sharing rooms. And if the people sharing rooms, if one person wins, the other one is still eligible. So that's something that is going to be a definite boon. We'll also, somewhere along the line, Peter Kelly isn't ready yet to tell us when, we're going to have a little bit of extra food for you following one of the afternoon sessions. He always has a barbecue that he puts on that's really nice, and we'll do an extra hotel room drawing at that time. Plus, for anyone who attends, how many classes, Curly? I can't. 8.
No, 7.
7, okay. We have 9 sessions, but for anyone who attends 7 or more sessions, at the end you'll also get a gift card for Starbucks. So we want to reward you a little bit for your extra efforts. All right, any questions anybody has about scheduling, substance, anything before we jump into the materials for today? All right, so we're going to talk, as I said today, we're going to spend most of our time on multiple choice, but I want to say a few words before we begin on essays. Now, I'm not ready to make my predictions today. Sorry about that. But they'll come a little bit later. However, I know that the commercial courses are asking you to write essays earlier and earlier in the process. And essay writing, of course, is important. And we will spend quite a bit of time talking about essay writing. So I want to just mention a few things to you to be aware of as you go into essay writing in a generic way. And then as we get into the various sessions, we'll talk about essay writing in the context of the different subjects. Now, remember, when you're writing an essay, you can't hide. So you have to know the law. You can't just look at a question and say, oh yeah, I think that looks like it's the rule, or I think that looks like it's the right answer. You have to know what the rules are, and you have to be able to say them. So careful study is essential to essay writing, which makes it difficult at first, because you're going to be asked to write essays in the commercial courses when you're really not ready substantively. There's no other way around it, though, because they have a lot of essays that they have to grade. So learn the substance. And how are you going to learn the substance? You have to dig into those long outlines. I can't emphasize that enough. Read the outlines. The more substance you know, the more rules you're going to know, the better your essays are going to be, and the better you're going to do on your multiple choice questions. You can do 5,000 multiple choice questions and still fail the bar exam if you don't know enough law. So read those long outlines. I know no one emphasizes them anymore, but they really do give you the detail that you need, particularly for the essays. So you learn the law, number 1. Number 2, when you get to an essay, whether it's a practice essay or the real thing, read the question. Well, that sounds stupid, right? But Gina was in my office a little while ago, and she had one of the past essays, and she said, well, I'm kind of stumped. I don't know, I have certain things I see, but I'm kind of stumped, and I don't know how to get past this little hump. So I said, well, we're going to read the question together. And we read the question together. And every single fact matters in these essay questions. On the Florida bar exam, you're going to see that for the essays, they're following the new approach, which is short, simple fact patterns, to the point. Multiple choice in Florida, that's a whole other ballgame. We'll talk about that later. But the essays are pretty well written, and they're very structured. Every fact matters. There are no red herrings on these exams. Now, some of your professors in law school will have written exams with facts that are irrelevant. And I got to tell you, That's real life, right? Because when a client comes into your office, the client isn't going to pre-screen the facts and say, let me tell you just the ones that are relevant, right? No, the client's just going to tell you this big, long story. But for the purposes of the bar exam, you will presume that the facts have been pre-screened. Every fact matters. So as you read a sentence, stop and say, what's this fact doing here? What are they trying to tell me? Which means you have to take a while with the fact pattern. Do not try to write your answer too quickly. Read that fact pattern really carefully. Make sure you understand what every fact is there for. And then, as much as you don't want to, you really, really, really need to make a good outline. And I know that the commercial courses now are kind of saying 10, 15 minutes, that's enough for an outline. I actually still recommend up to a half hour. You know, each essay is worth an hour. Up to a half hour to make a really good outline. Why? Because you do all of your thinking up front. If you think first and then write, it does not take you very long to write or type your essay. Because you're looking for 3 or 4 pages max in terms of the essay. How many of you, by the way, are handwriting? And the rest of you are typing? And those of you who are typing, you've already signed up for ExamSoft? Anybody not? Get on it, because you got to, I think, January 20th, I think. There's a deadline coming up fairly soon for ExamSoft. So make sure if you haven't signed up for it yet that you do that. Now, make a good outline in IRAC form. They are looking for an essay in IRAC form. And when I say IRAC form, not just one big issue and a blob of rules followed by a blob of facts and a conclusion. You want to IRAC in tiers, if you will. And you IRAC each element of a cause of action or each component of a rule, each requirement. So a series of mini IRACs. And each one in your outline should be complete. Identify what the issue is. State the rule. Put a little snippet of the facts and your conclusion in your outline. If you put it in the outline and follow your outline, it ends up in your answer. And once again, that's the time for doing your thinking, because what you want to do with your answer is to duplicate the grader's outline. The person who is grading your essay is not the person who wrote it, which of course is unlike law school. I grade the essay, I wrote it, so I know what I'm looking for. The graders, for the purposes of the bar exam, they are people who had the misfortune of doing extremely well on a previous bar exam. And we've had a number of people from St. Thomas who have been chosen for that honor. If the bar knocks on your door and says, we want you to be a grader, you can't turn them down. You really don't want to say no to the bar if they are offering you this wonderful privilege of reading all these essays. But the grader gets 300 essays to grade in a very short period of time. And so you want to make it as easy as possible on the grader. The more organized you are, the closer you come to duplicating the grader's outline, the more points you're going to get. And it's all about getting points. We have had some spectacular essay scores over the last couple of years at St. Thomas. Really wonderful essay scores because our students have really dug in and practiced. As many essays as you send to me, I will read. I got 17 essays from somebody last summer, read every one of them. That student passed and got really nice essay scores. Not that I'm encouraging you to send me 17 essays, but I will read them if you send me 17 essays. And you can send me the essays that you've written for your commercial courses, and I'll grade them as well. So then you get 2 sets of eyes on one essay, so it's efficient. And when I grade the essays, those of you who've had me for class and you've seen how I mark up exams or practice exams, I write comments all over them. The commercial courses will give you some points and a couple of remarks, but they can't give you a lot of detail. They have too many essays that they have to grade in too short a period of time. So I will give you detailed feedback, and it's not a large group in February, so I should not have any difficulty in handling the essays.
I know, I mean, in law school, a lot of professors took off for spelling. Are they looking at that?
Good question. It's not an English exam. However, you know, spell as well as you can, and proper English, writing in full sentences with proper English, it does help. Now, when I say spell as well as you can, my rule always is, if you don't know how to spell a word, don't use it. And when there are words that you're going to use over and over again, you know, everybody knows, I hope, at this point, how to spell plaintiff, right? Okay, so words that you know you're going to have to use, pay attention to how they're spelled, because even though it's not an English test, when your grader is reading quickly, it's very jarring to see every other word misspelled, to see grammatical errors over and over again, and it has a psychological effect more than anything else. And those little psychological effects can make the difference on a couple of points, can make the difference between passing and failing. Keep it simple. If you're not real comfortable with your writing skills, short, simple sentences. First of all, if you write, and you know, you learned in your legal writing class 25 words or less. It's a really good rule for the bar exam, because number one, if it's a short sentence, you're less likely to make errors. And number two, short sentences are easier to understand. And think about it. When you're reading something that's got a sentence that goes on for 15 clauses, you get lost, right? Short little sentence with a period, stop, much easier to comprehend. And your job is to make the grader understand what you're trying to say. And trying to duplicate the order, again, in which the material is presented in the grader's outline. Now, the grader's outline, as I mentioned, is written by the person who wrote the question, who is not the grader. Oftentimes, they get people from other states. I've written questions for California and Arizona. They won't use professors from Florida law schools to write the Florida questions for the obvious reason. And as we go into the subjects, I'll be talking to you about places where they get their ideas for the questions. We'll do that in the various topics as we go subject by subject. And remember, your grader didn't write the question or the answer. So your grader is going to be restricted to the grading outline. And what they do is, once the exam has been administered, they gather up all the essays, and they have what they call calibration sessions. They get all the graders together, and they give them a sampling, probably 40 essays or so. And they grade them very quickly over a weekend using the grading outlines, and they make notes. The grading outline works here, it doesn't work here, I think we should have more points for that. You know, you make notes, and then everybody comes back together. And they sit around and they talk about it. Now, I, some years ago, participated in one of those sessions, a mock session, but they were demonstrating to us how the process goes. And what you do is you sit around and you talk about the essays that you read and the grading outline and how closely the essays match the grading outline. And they get to calibrate or adjust the grading outline at that time. If everybody thinks they should give more points for topic A, they'll adjust the grading outline. If everybody thinks topic C should be eliminated, they'll adjust the grading outline. Once they're done with the calibration session, that's it. No deviations from the grading outline. So understand that. The creativity that may have helped some of you through law school, and honestly, when I'm grading an exam, if somebody writes about something that I didn't think about or intend in an essay and it's really good, I'll say, oh, all right, yeah, got to give some points there. Graders can't do that. They are restricted to the grading outline once the calibration session is done. So don't get too creative. Stick to the issues that are clearly presented and write about them in the way that you project that the grader will want to see them. What it also means is don't spend a lot of time on negative issues. Once again, some of your professors may have encouraged you to write about all sorts of stuff to see how much you know. The bar exam is not, at least for the essays, is not testing how much you know. It's can you answer the questions that are presented. If a question, for example, Suppose that you have a products liability question in torts, which is certainly possible. They love to test it. You're not going to get any points for saying there are no intentional torts in this question. There are no dignitary torts in this question. No points. Use the facts as your guide. If the facts raise an issue, discuss it. And you might say, for example, yeah, definitely products liability is an issue because we've got a defective design. At least a defective design has been alleged. But it's not a defective design because, as you'll learn, there was no reasonable alternative design available, which means then that they couldn't do anything about the design. That's not negative issue spotting because the facts support a discussion. You might say yes, you might say no, but the facts support the discussion. However, going off on a tangent and telling them all the things that it is not will get you no points at all, and in fact, going back to that psychological factor, I can assure you that your grader is going to wonder if you really know what the issues are. And in that grading session that I attended, we sat at tables. There was a professor at each table. There was a judge at each table. There was a member of the Florida Board of Bar Examiners at each table and a practicing attorney. And as we talked, every time somebody picked up what I call a kitchen sink essay, one where everybody's just shoveling, everyone, no matter who it was, said the same thing. Or this person doesn't know what he or she is talking. This person is just shoveling information. That will not get you a good score. Pointed, answering the questions that are asked, not answering questions that are not asked, and sticking to what the facts ask you to discuss. That's how you get a good score. And you will have points allocated for spotting issues, for stating rules, for applying the rules to the facts, and for drawing a conclusion. But you should draw a conclusion. Sometimes the conclusion is very clearly based on Florida law. And if you know the Florida rule, then you know what the answer is. Sometimes, though, if it's fact-driven, could be yes, could be no. We're going to have some questions that we'll work on that fall into both categories. It is important to say yes or no. If it's fact-driven, it will not matter at all whether you say yes or no. If it's Florida law-driven, then of course it will. And I can promise you that except in a few areas, contracts for example, these questions will have Florida rules in them. So if you write, going back to products liability, if all you write is a multi-state answer, you're not going to get a great score. You have to know Florida-specific rules. Yes, sir?
For us who are not the fastest typists, knowing that there's a time limitation on everything, say I do a solid outline, I find there's 5 serious issues I want to address, and I have it on my outline, and I get like 10 minutes left. Should I finish my 3rd issue completely, or should I put an issue in? Good question. Or just put the rules on the issues? Where do I get the most points?
Yeah, very good. It's a combination of things, and I'm going to tell you, you'll see as we go through some of the questions that I do, I make very, very thorough outlines for you, which you'll get as part of the materials in this class. And many of the essays, the answers that I've written, couldn't be written in an hour's time. And I make them very thorough so that you have a study guide. You're going to see when you look at the answers that are included in your commercial materials, they tend to be shorter and they leave stuff out. They're trying to give you an example of something that can be written in an hour's time. I give you something that maybe can't, but that has all of the issues. You need to show them that you can do some good analysis. So at least some of what you've written needs to be in good analytical form. And, of course, you do need to show them you can spot issues. So kind of a combination, which makes it important, again, to spend time getting your ducks in a row before you start to write. Because if you can see what the main issue is, then do a good analysis on the main issue. The question that Gina asked about had a really meaty statute of frauds issue. And then, interestingly, it raised venue. This is a contracts question, and it had venue. It was a choice of venue clause in a contract. That's actually considered to be Florida con law. They threw a little Florida con law in there. Spot that issue. See the difference? Because you're not going to get a lot of points for the venue issue, but spotting it, you get something. statute of frauds, meaty, that's where you want to put your efforts. So again, pulling back up at front and doing what I call a little bit of triage. Which are the important issues can help a lot. Other questions?
Can you take the exam for us?
Can I take? You know, over the years, I've been asked that a lot, and I would not have to be here now. I'd be very rich and relaxing on some, remote island if I could do that. And it requires a thumbprint transplant, but yeah. Yes, sir.
Some people who took Art of Lauren had this program, Adaptabar.
Yes.
Is there any way of getting access to that without taking Art of Lauren?
Adaptabar you can buy.
Without buying, let's spend $400?
Yeah. There are ways to do all sorts of things. I'm not going to talk to you about that particular, because,
Right.
okay? But, however, we do have available for you, and I should have mentioned it. It's probably in here someplace. I skipped over that. The release questions, it's somewhere in here. Yes, the second page. We will subsidize your purchase of release questions from the National Conference of Bar Examiners. And Adaptabar, by the way, is populated primarily with release questions. So you can purchase these questions. And I can tell you that the National Conference of Bar Examiners, which writes and administers the MBE portion of the exam, they say, if you want to practice any questions, practice our release questions. They have some old release questions that are really old, in the old style. The law's outdated. You don't want them. But they have 4 new released sets available. And I would use those released sets. They show you the types of questions that the examiners are writing now, written by the people that are actually writing the questions on the exam, and they are recent enough that the law is going to be valid as well. So follow the instructions if you want to purchase those here. For Adaptabar, talk to somebody who's got it. But beyond that, I can't really say anything else. Yes, sir?
How do you feel about statutory citation in the essays?
Okay. It's a good question, too. If you know a statute number, you can certainly cite it, but don't use it as a shorthand for the rule. So, for example, suppose that the question is adverse possession, and you're talking about adverse possession in Florida. Well, it's 95, 17, and 18, I think, are the numbers, or it could be 16 and 17, but it's Chapter 95 and 2 sections. If you know which ones are applicable, one is with color of title and one is without color of title, you can cite the number. That's great. But don't just say the number. Say the rule that goes with the number. And the same goes for cases, which may be your next question. There are a few cases, as we'll see when we get to Florida con law. If you're talking about access to courts in Florida, it's a big deal. They love to test access to courts. I just want to give you a heads up as you're studying your Florida con law materials. If you did not take Florida con law, you're going to have to study that subject carefully because they love to test it. Access to courts is one of their favorite topics. Well, there's a particular case, Kluger versus White, and they call it the Kluger Doctrine, that deals with access to courts. If you say the Kluger Doctrine, everybody knows what the Kluger Doctrine is. But otherwise, if you cite just a case without saying a little bit about what the case is about, it may not be real helpful. Now, when it comes to numbers, for example, evidence is one place. You're not going to have an evidence essay probably. But in contracts, you could have a contracts essay that deals with Article 2, for example. I learned Article 2 by the numbers. And so you're going to see when we get to contracts and I talk about Article 2, the first thing I do is spout the number. And as soon as I say the number, I know the whole rule. But you'll see when we get to evidence, when I learned evidence, I didn't learn it by number. So I have to really stop and think about the number. If the numbers help you, then use them. If they don't clutter your brain with numbers or case names. That's the key. One,
say like the hearsay rule says.
perfect. Exactly right. You don't have to say 801 unless 801 helps you remember the hearsay rule. But I do want to make one caveat there. When it comes to Florida con law. Mostly you don't need to know section numbers. You might say Article 1 for the Declaration of Rights, because that's pretty easy. Federal constitutional law is the one place where they do expect you to know numbers. And you'll see, particularly when it comes to multiple choice, you have to know the difference, for example, between Article 4, privileges and immunities, and Amendment 14, privileges or immunities clauses. So knowing numbers does matter there. Otherwise, unless it helps you, don't worry about it. Other questions? Anything else about essays? Again, we'll talk more about what I think they're going to test a few weeks into our sessions. Yes, sir?
Very briefly, you recommended going over the long outlines, which I don't agree with you. But would you recommend just a highlight method? Or, because like trying to note card that
right.
is insane.
Yeah, exactly right. If I was talking to a group of students who are studying now for the July exam, I would say, wow, rip out those note cards and start writing away if they help you. You have a limited amount of time because it's already January. First of all, the February exam comes earlier because February is a short month and you've got the holidays at the beginning, and so you usually get a couple weeks less to study for the February exam. And those weeks are crammed full of study. Generally speaking, you do not have time to make your own outlines, to make note cards, to do the things that may have served you really well in law school. So you're going to have to stick to the program as much as possible. However, know how you learn. And everyone learns in a different way. I'm very visual. I do have to read. I don't listen well. It's not that I don't listen well, but I don't learn by listening. And I'm a little kinetic, but not a lot. Sounds like you might be very kinetic. You want to emphasize the things that you know work for you within the time constraints. One other thing that I want to suggest to you, and I am saying this to you after consultation with Barbary. How many of you are taking Barbary? Okay, most. Yeah. For those of you who are taking Barbary, don't get overly hung up on the AMP program. The AMP program is wonderful before you get to the time period that you're in now. But if you spend all your time doing AMP, you're not going to get the learning in that you need. And Barbara's aware of that. They really did design AMP to be used. If you were taking the exam in July, now would be the time to be doing AMP. So if you find your time limited, the first thing that you set aside, and again, we had a meeting in my office a couple of weeks ago with the Barbary folks to talk about this particular point. Set aside the AMP. Don't overuse it at this time.
Something, just a statement is for what you just said. Having taken the Barbary and having done the multiple choice questions, I will say without a doubt that their questions are a lot easier than the actual MBE questions. So the sample questions are much more harder. Also the Kaplan seem to be a little harder too.
Yeah. It's a good point. My advice has always been over the years to mix it up when it comes to multiple choice questions. If you rely too much on any one source, you get comfortable with that style, and that can be problematic when you get to the exam. Because even if you do questions from a lot of different sources, you're still going to walk into the exam and you're going to go, whoa, how did they come up with that kind of question? And it always amazes me, and I've written a lot of questions for a lot of exams over many, many years, and I like to think I'm pretty creative when it comes to multiple choice questions, but they come up with new and exciting ways to test you. So mix it up as you can. If you're doing Barbary, do some Kaplan questions. Do those release questions. That's the most important thing. If you're doing Kaplan, then do some Barbary questions. We have, as you all know, we have sources upstairs in my office. If you want to supplement your multiple choice questions, you can always come upstairs and we can help you out with that. But definitely mix it up. Don't get too comfortable with any one question mode. Other questions? Yes, sir.
During the bar break, we set aside the end because we're falling behind. What should we prioritize? The long version, the many view
Yeah.
version?
Though the convisor outlines are wonderful when you get to the end. And I will tell you, when I studied, which was a long time ago now, I read all the long outlines, went to the lectures, did the few multiple choice questions that were available, and then in the last few weeks before the exam, the only thing I used was the convisor. But don't start with the convisor. It doesn't have enough substance. What you learn with the convisor is half rules. And they'll give you the first part of the rule or a summary of the rule. They don't give you the detail. Now, if you've already learned the rule, when you read the convisor, you fill in all the rest of the information, right? But if you use the convisor as your only source, you never get the rest of the information. And I can promise you, when it comes to the exam, do they test the basic rule? Nah, too easy. They test the exception to the exception. And that's what you get from the long outlines. The devil is in the detail when it comes to this exam. All right, so let's talk about multiple choice, because that's our topic for today. And what do you do with multiple choice questions? Now, let me ask you, before I spend too much time on this part of the lecture, how many of you took either AOL when it was called AOL or Advanced Legal Studies? Some of you, okay. It looks like about half. So I'm going to spend a little bit of time then, and let me back up. How many of you did the 6-day with Kaplan or the 5-day with Barbary? Yeah, okay. So we're going to take a little bit of time talking about a classic question format, and then we're going to do some multiple choice questions. So then I'm going to go back. All right, let's look at this one here. Your typical MBE question now falls into a pretty standard form. There were some revisions 6 or 7 years ago now, I think.
Are your slides?
The text was, did they include the text in the packet? Ooh, you know what? Maybe it wasn't. We'll get that to you. First of all,
You have MBE questions here.
yeah, you have the questions, but there is text that goes with it, and we've got the essays, and somehow we left out the multiple choice. So we'll get we've got your email addresses. Did you all put an email address on the sign-in sheet? Okay, great. We will where is the sign-in sheet? If you haven't signed in, please sign in. We will email the text to you. You should also know that all of this material will be posted on the web course, which is a Lexis web course, not Twin. All of the hard copy materials are up there in electronic form, and you see that we are videotaping. We're going to videotape each session. We publish it through YouTube, but it's not generally available in YouTube. You have to go through the web course to get it so that the whole world doesn't have access to our lectures. So if you want to see a lecture again, for example, suppose that you come to Professor Martin's lecture next week, but you really don't know anything about Article 9, you might want to listen to that part again. You can access it. And please tell your friends. There are some people that I've communicated with or talked with who are studying in remote locations. They can also access all of the lectures and all of the materials online. And for those of you who haven't signed up, by the way, for the web course, just open enrollment, so you don't have to have a password or anything. And also, good idea to check the Facebook page as well. Changes in schedule and so forth will be posted on Facebook. For obvious reasons, I don't post any substance on Facebook because, once again, that's out there for the world at large. Okay, so your typical MBE question today, and for the purposes of the MBE, they will follow these rules pretty rigidly, has a format. So let's take a look at that format so you know what you're working with. It will be different from the format that you may have seen in some of your law school classes. Those of you who had me for a class somewhere along the line, you're going to be familiar with this format already. And some of your other professors, of course, if you had AOL or ALS, whatever it was called when you took the course, you will also be familiar with the format. You start out with a fact pattern, a relatively short fact pattern. They like to restrict the fact pattern to 500 words or less now. So it isn't always restricted to 500 words or less, but that's what they aim for. Sometimes it's a lot less. An evidence question, for example, can be just a couple of lines long. So you start out with that fact pattern. We'll read this question in a second. Then you've got a call of the question. The call of the question is going to be very directed. Yeah, Frank, you can hand that forward, thanks. They have really worked on making, there you go, Dean, making the call as specific as they can. So it's going to be a very specific call of the question that usually, not always, but usually is going to ask for a yes or a no answer. And you will have 4 answer choices, no more, no less. Don't pick E or F or G. Doesn't help a lot. So we have 4 choices. Again, we're going to read the substance in a second. And you're going to have 2 pairs, 2 yeses and 2 nos usually. Not always. And you'll see as you go through the release questions, if you order some of those, that sometimes they use other forms. And of course, all bets are off when it comes to Florida multiple choice, which we'll talk about later. They tend to put the no first instead of the yes. Personally, I kind of like the yes first. But in any event, 2 yeses, 2 nos, or 2 nos and 2 yeses. And importantly, alphabetical order within the pairs. And you're wondering, why? You cannot go through in Christmas tree or pick all C or pick all D or whatever they're telling you to do when you don't know what to pick and be successful. You could, and it's done so that the choices are not necessarily equally distributed, A, B, C, and D. And I will tell you, before they made these changes, when I put together a multiple choice exam, I would try to spread the answer choices out so that they were evenly distributed in case somebody did decide to pick one letter, bubble in B all the way down, and that person either got really lucky or really unlucky. It's totally random now, however it comes out alphabetically. One of these is going to be correct, and 3 are going to be incorrect. You're going to have a right answer, sometimes called a key, and then the others are the wrong answers, the distractors. You want to try to not get distracted by the distractors. We're going to talk about some of the classic distractors in the various subjects today. So let's now go through this question. How do we answer the question? There are 2 approaches, and if you haven't already tried them both out, either in your commercial courses or through AOL, ALS, try them both out. Even if you have been directed to use one, try the other just to try it out. You can start with the fact pattern and then read the call of the question, or you can read the call of the question and then go back to the fact pattern. There are advantages and disadvantages to both approaches, and let me tell you what they are. Try them both out because it's very individual in terms of what works. I start with the fact pattern and then I read the call. Many of you probably start with the call. What's the advantage of reading the fact pattern first? When I read a fact pattern, I do the same thing that I talked about with the essays. I interact. What's this word doing here? What's this fact doing here? What are they trying to tell me? And the more that I interact with the fact pattern, the better job I do of predicting the call of the question. And if I've done a particularly good job of predicting the call of the question, by the time I get to the call of the question, I'm already 3/4 of the way home, 7/8 of the way home. I'm going to get the right answer. For me, it's also important not to read the call of the question first, because reading the call of the question first can help you screen the facts, which is why a lot of people start with the call. But if you screen the facts, especially for somebody like me, I'm a very fast reader. I get very impatient. I like to just zip through anything that I read. Every word counts in these short fact patterns. You miss one little word and you get the question wrong. So if you're a fast reader, then you don't want to read the call to question first because you're going to just automatically screen stuff out. If you're a slow reader, you might want to read the call to question first because it helps you screen. But it adds a little bit of extra time because you have to read the call and then the fax and then the call again. So try them both out. It's individual, see what works for you. All right, so since I like to go with the fax first, we're going to go with the fax. And we start out with a 5-year-old girl who's playing right there. That fact is suggesting something to me. 5-year-old girl, what am I thinking about? I got a kid, right? In what case do you have? Just, yes, Garrett versus Daly, exactly right. Now, you might not remember the name of the case, but it's the 5 3/4-year-old kid who pulls the chair out from underneath. Yeah, see, everybody remembers that case. Use those facts. Almost every question that you will see on the MBE portion of the exam is based in a real case. That's how they write their questions. And if you can remember the case and remember the holding in the case, you're going to get the right answer. Particularly important when it comes to constitutional law and criminal procedure. Those questions, because they're based on holdings of the U.S. Supreme Court, have to be based in cases. You cannot make up what the Supreme Court's going to do. It does what it does. It's the Supreme Court, right? And so the only way to know what the right answer is to know what the holding is in the case. Garrett versus Daly, this particular question is actually based on a different question, a different case, which I pulled from the notes in Prosser. So remembering cases is really important. So we've got this little girl. She runs into the front yard of the house next door, which might make you think about what? Trespass to land. Remember, we've got trespass to chattels and trespass to land. Trespass to land. And then there's a boy, and he's 7 years old. Now, if the 5-year-old didn't catch your attention, by the time you see 5 and 7, you have to be thinking about Garrett versus Daly. And he sees her, he grabs his bow and arrow, moves to the edge of the porch, and he says, if you don't get off the lawn in front of my house, I will shoot you with this bow and arrow, which is apparently what the kid really said in that case. What does that make you think about?
Assault.
Assault, yeah, absolutely. It might not be assault because it may not be immediate enough, but it makes you think about assault. Now,
And then the father being there as well.
okay.
Seeing him do it, not letting him do it.
Okay, good.
Vicarious liability.
Okay, could be vicarious liability too. And what you see is the facts are leading you, because now you've thought about several intentional torts. So I drafted this question in a way to show you the clues that you want to take from the fact pattern. It's leading you to intentional torts. And what you want to be able to do with your brain as you study for the bar exam is to get it organized. It's got to be like a computer database. If you say to me, torts, okay, I scroll to that part of my brain. And then I say, oh, intentional torts. Now I go down a couple levels. And then, oh, intentional torts to the person, intentional torts to property. And then intentional torts to the person, oh, assault, battery, false imprisonment. I'm going down in layers. I know where to look for the information in my brain. How did it get in that order? By the long outlines, folks. Because the long outlines are organized. And the more organized the information is in your brain, the easier it is to find. Think about your closet, or think about my closet. Some years ago, when I moved into my condo, I didn't renovate the closet. It's a nice big walk-in closet, but it had these old wire hangers in there, and I just left it. And then kept hanging stuff on it. And one night, the whole thing came down. Fortunately, I wasn't in there when it came down, but it made me get California closets to come in. Well, they come in, they give you all these little cubby holes, and you put stuff in the right place, and then you know where to find it instead of just throwing it on the shelf. If all you do is questions, you will learn law, but then your brain's going to look like my closet did before I got California closets in, just throwing stuff on the shelf till it all comes crashing down. You'll have information in your brain, but you won't know where to find it when it comes time to access it. And if you learn information just by doing questions, the question becomes the trigger for the rule. And if you don't see the same question, you don't remember the rule. So learn the information from the outlines in an organized way, and now I'm down to intentional torts to the person. And guess what? He hits her in the eye. He's intending merely to frighten her, assault, but he hits her in the eye, and so we think about what? Transferred intent. See how it works. So I've worked my way down, and I know the call of the question is going to be battery. And so I already know what the answer to this question is. But let's look at our answer choices. A says yes because the boy intended to frighten her. What do we think?
It's true.
True. It's true. Now, you never pick the first answer that looks good, because you never know. It could be a better one later. Always read all 4 choices. We're going to see that A is the right answer, but don't stop. Even in the name of time, don't stop, because you never know what comes after. But yeah, if he intended to frighten her, transferred intent, or, you know, depending on who your professor was in law school, you may have used the restatement definition of intent for assault and battery, which combines the two. But you get to the same place, whether you use the restatement definition or you use transferred intent. B says yes because the boy was negligent when he aimed in her general direction. Now, was he negligent? Yeah, probably he was. Why is this answer wrong? It's a classic distractor in torts. Call of the, very good. Look at your call of the question. Your call of the question deals with an intentional tort. B deals with negligence. And in tort questions, they love to give you one tort in the call of the question and a different tort in an answer choice. B is a nice juicy distractor if you're not paying attention and if you didn't circle or underline battery.
Can you count on them giving you the cause of action in the call?
Not always. In this particular case, I had to include it because otherwise B could have been a right answer, right?
So don't count on it.
Don't count on it. But, for example, if you have a products liability tort question, they may well not tell you which products liability tort you're talking about, because products liability is the big umbrella, and underneath it you have strict products liability, negligence products liability, warranty products liability. Then you may have to choose.
I also, just to mention this, I also seen like in past MBE questions that I've been like working with, it'll say like, it'll give you like a clear pattern of like strict liability, like let's say strict animal liability, but then it'll say like under negligence theory.
Okay.
In the call of the question. So then it throws you off when you're reading and you're like, you're thinking strict liability already. But you should be looking at it through negligence.
Right.
You know what I mean? So,
Yeah, always focus in if they give you a call of the question. And notice in this fact pattern, and you mentioned vicarious liability, I could have drawn this question to talk about the father's liability. Could have been vicarious liability issue. So the call of the question does become important, the tort. And if they tell you the tort, then follow it through in the answer choices. If they don't, it's because they're asking you to rank the best or the least effective cause of action. So the other two, C, of course, says no because he only intended to frighten her. Well, that's wrong, transferred intent. And D, no because the boy was only 7 years old when he shot. All you have to do is think about Garrett versus Daly, remembering tort, not criminal law, right? So his age, as long as he's old enough to understand what he was doing, which is what the court said in Garrett versus Daly, the age is not going to preclude liability. Any other questions or comments on this particular question? All right, so now we're going to do the question set that you have. Well, we've got, I think it's 10 questions. We will be, by the way, today we'll be done by 5 o'clock, which will make you all very happy so you can go study some more. Most of the rest of the sessions will last the full 3 hours. This introductory one always is short. But before we do the questions, a couple of comments. We're going to use the clickers. Anybody not use the clickers? They're nice, shiny, brand new, but they work the same way as the ones you've used in the past. I like to use the clickers so we can get a good discussion. We have to go one question at a time, of course, since we're using the clickers. But what I want to do before we do, we'll go ahead, since we've been talking for an hour. I'm going to grab your raffle tickets, and we'll go ahead and do the drawing.
Just your name?
Yeah, name and phone number. We need the phone number on the ticket, because name will be fine for me, because I'll call your name out. But then we're going to contact you from upstairs, and they like to have a phone number. Yeah, if you need to take a break, now's a good time to take a quick little break.
5 minutes or?
Yeah, go ahead.
Make sure she picks that one I gave you, okay?
5 minutes, yeah. Oh, yeah. And when we take breaks, of course, the sooner you get back, the sooner. Sorry about that. I didn't think about that. Let me walk around this way. Tickets are all in. All right. Yes, ma'am.
My Kaplan photo essay workshop is coming up in a couple of days. I was going to wait for that workshop, and then I'll get into starting to apply
Yeah.
IRAC and stuff to practice and send.
Okay. That sounds good. Yeah. While we're on the break, and I see Dean filled out his lunch form. Anybody else got a lunch form you want to turn in?
Lunch,
Yeah, lunch, important stuff. Thank you.
If I were to bring my own lunch, is there a place where I can keep it? Like, can I keep it in my car at the...
You could. You cannot take it into the exam, of course. And the other thing that people have done, although I want to confirm it with Mercedes to make sure it's still okay, people have left things underneath their table outside. They'll have. We won't know until we get really close where they're gonna, what room they're in. But they have a little table outside, and people put stuff underneath it. So you could probably do that as well if you didn't want to leave it in the car.
Because this is so complicated that the time that I get hungry is like 10:30 or 11. So so I have to eat earlier. And
Yeah.
then,
Oh, okay.
And then,
But you're not going to be able to go out to get your
Right.
lunch. So you're going to, for the 3 hours that you're in there, you're stuck.
because I asked them, and they're like, you need to get a doctor's
Yeah.
note to bring in
Right.
lunch. I'm like, okay, I'm not doing
Yeah,
that. So
yeah,
I'm just
good.
going to eat before. And
Okay.
then, so I'll just leave my stuff in my car if I don't get that.
Okay.
But that works. Okay.
Okay. Okay. Anybody else on the lunch form? Frank? Okay, you're welcome.
For too long, okay? Just one of the other person that was with us yesterday and one new person.
All right.
So
Let's
3 of us.
go ahead. Yeah, please feel free to grab more pizza. There's plenty there still, I think. All right, and you can see I'm mixing this up really, really good.
Oh, you're drawing now?
I'm going to draw now, yeah, because we're on the break. We are on break. Yes, what can we do for you?
Is there a way we can get in your 5 minutes to replace the wireless? Or are you guys not going to be on break that long?
You were kind of done with the break?
Okay, that's fine.
Yeah.
That's fine.
Yeah,
Thank you.
okay. All right. Going once, going twice. I'm going to draw. And remember, again, it's a small group, so your chances of winning, if you don't win today, if you come back again for the next lecture, your chances are good. Okay.
Just don't tell everybody.
Where's John? Rundle.
John is not here.
He's not here.
Goes back in the bucket.
John, who's John?
That didn't make sense.
What's the name?
Oh,
yeah,
John.
Matthew.
Oh, John, yeah. Okay. Okay, well, He won. Okay. You guys all get the chance. Yeah, what? Right, you must be present. If he, well, he left his laptop. If he didn't come back, we might know. But
Or it could have been abandoned.
It could be abandoned. And it's abandoned if he voluntarily placed it and he voluntarily walked away from it. Now, you'll see when you get to property, unfortunately, you remember that rule, they don't test personal property on the bar exam. But still not a bad rule to know, because abandonment of real property could be an issue, particularly in the context of landlord-tenant. That they do like to test. All right, so what we're going to do now, let me go forward a little bit. Pull out your question packet, and you guys all know how it works. I'll hit the green button in a second. I have to fill in. You won, John, yeah. You get a hotel room, yeah, see? Sarah and Carlene will contact you, John, and we'll give you the instructions. You have to do reimbursement, of course, for it, but it's a pretty easy process. So there is $1, just so that you know, and we have run into this before, there is a $1 limit. So if you get the presidential suite at the Marriott, we're not covering the whole amount, okay?
It's $300.
$300, yeah.
Ooh, I need to know.
Yeah, and we've had people do all sorts of, attempt all sorts of interesting variations on the theme. One night, up to $300, which is still pretty generous, I think. Okay, question number 1. Yeah, is your light on?
No, it's not going to tell you. You just click it.
Yeah, you just click.
Oh, the numbers moving,
Yeah.
indicating that we're pressing, right?
Okay, yeah. It's okay if you press twice. It's only going to count you once, and you can change your answer if you want to change your answer. Yeah, just the first question. Okay, everybody is registered. Now, notice something. A minute and 15 seconds it was on that one. Let's see how we did. And almost everybody got it right, because D is the right answer. I like to start out with an easy question. And so you shouldn't assume that all of the questions on the bar exam, of course, are going to be this easy. However, sometimes they are easy, and don't overthink it. I see a lot of people who look at a question and who say, "Oh wow, yeah, come on in. It looks too easy. It's got to be harder, and there must be a trick." Sometimes there aren't tricks, so don't overthink again. On this one, though, of course, D is the right answer. Let's talk about why D is the right answer in this question. Another fact pattern that I just stole from the Prosser casebook. It's an actual case. So we've got a kid. He becomes obsessed with a particular band. He loses touch with reality, and he commits suicide. And the mother brings a wrongful death action based in negligence. So here we do know what the call of the question is. It's negligence, so we got to pick an answer choice that is negligence-based. What's missing in A? Causation. Many, many years from now, when you guys have been practicing 30, 40 years, you won't remember very much of anything from law school, or you'll remember even less from the bar exam. But you will remember negligence, duty, breach, causation, damages. A doesn't address causation, which of course is an essential element of negligence. Think about your elements in order. When it comes to negligence, take those elements in order, because if there's no duty, who cares about a breach? If there's no breach, Who cares about causation, etc. So A leaves out causation. What's wrong with B? Different cause of action. Severe emotional distress, that's intentional or possibly negligent infliction of emotional distress, but that's not the call of the question. So make sure that you match your answer choice with the call of the question. As an aside, however, for essay purposes, when it comes to writing essays in the torts area, intentional infliction of emotional distress is a very popular cause of action. So look for it in the fact pattern. It is a cause that shows up all sorts of places. C, what's wrong with C? Intent, same problem that we just discussed. Okay, any questions about number 1? If not, number 2. Okay, we're coming up on 3 minutes on this one, so if there's anybody else who wants to ring in. All right, I'm going to call it. Now, before we look at the right answer in this question, I gave you 3 minutes on purpose. It's a longer question. You will see that contracts and property questions tend to be longer than other questions. As I mentioned, evidence, they can be really short. You took 1.5 minutes on the first question. You're going to be told, you've probably already been told, 1.8 minutes per question, hit it, move on. Don't be so mechanical about that particular rule. You do have a time limit, and you have to learn how to pace yourself. However, it's really important that you don't shortchange longer questions, because sometimes the longer questions are the easiest questions. Not necessarily true on this one, but we're going to see some other questions where the longer questions are very easy, and the examiners know it. They know that people will skip over the long questions or rush through the long questions, and so they will have a payoff for those who take the time with the longer questions. And this particular question is one of the longer ones. So let's see how we did. And there's no way for me really to do it because B is the right answer. Let's talk about why B is the right answer. Now, what's the first thing you have to do with any contracts question, whether it's essay or multiple choice? What is my governing law? Absolutely. Doesn't matter whether it's essay or multiple choice. The first question you have to ask yourself is governing law. You have to know which set of rules to apply. And in this particular question, we're talking about glass jars, and so the governing law is? Yeah. I always say Article 2 because there are 9 articles in the UCC, but UCC will do. So we are applying Article 2, and this particular question is all about 2207, that murky bit of prose. If you didn't learn 2207 in your contracts class in your first year of law school, you've definitely studied it. Whether you learned it's another thing. Go back and learn 2207. You will have at least one 2207 question on the MBE portion, and they like to test it on the essay portion of the Florida exam. The rule in Florida is identical to the MBE rule for 2207. So we have to follow the steps of 2207 through in this question. Let me get the back pattern here so I don't have to scroll up. So the first thing you have to do in 2207, you go to 2207 subpart 1, which says, do we have an agreement? And yes, we have an agreement if we have a definite and seasonable expression of acceptance. Did we have one here? Yeah, because we've got form number 1, which is the purchase order, followed by form number 2, which is the acknowledgement that says, yeah, I'm going to buy the jars. So there is an agreement formed. The question is, what are the terms, of course? And then we go down to subpart 2 to deal with the additional term. Now, subpart 2, it's important to distinguish between merchants and non-merchants. If both of the parties to the contract are merchants, you have one rule. If neither is a merchant or only one is a merchant, you have a different rule. If no one is a merchant or only one party is a merchant, then that additional term is simply an offer for an additional term to the contract that can be accepted or rejected. If, however, both parties are merchants, then you go to the traditional part of subpart 2 that you learned. And are they both merchants here? Sure they are. Why are they merchants? Because they both deal in goods of the kind. So, as between merchants, the additional term becomes part of the agreement unless one of 3 things. And it's disjunctive here, any one of the 3. The first is that the original offer was limited to its terms. Rarely occurs, and it definitely was not in this case. The second is the one that's usually the issue, so we'll come back to it in a second. And the third is that the offeror objects when? They'll get you on that. That's the devil in the detail. Within a reasonable time. The 10-day rule, it's the merchant's exception to the statute of frauds. 2201, not 2207. I'm telling you, it's those teeny little details that make a difference. So, for 2207 subpart 2, it's an objection within a reasonable time. Well, that didn't occur here. So we're back to the second exception, which is a material alteration. Now, what amounts to a material alteration? Something that causes undue hardship or unfair surprise. And the cases tend to fall into 3 categories. The first is a change in the statute of limitations. The second is a disclaimer of warranties. And the third is an arbitration clause if arbitration is not a custom of the industry. So when you read the questions, again, they're going to be using real cases. They're almost always going to involve one of those three things: change in the statute of limitations, disclaimer of warranty, or an arbitration clause when it is not a custom of the industry. And so the question is, what's the statute of limitations here? Now, the kicker here is, if you go back, and I think probably a lot of you went to D because you said, well, it's an additional term and there was no objection, right? How many of you, that was your rationale? Ah, but you missed something. You missed the gap fillers. So you got to go back, and I purposely went through the facts that way because it's the way most people were thinking. I said, oh yeah, we got an additional term, statute of limitations. Not true, because the first offer, if you will, which is the purchase order, didn't say anything about statute of limitations, did it? So what's your default gap filler statute of limitations under Article 2? 4 years.
We never did that.
Thanks, Professor Torgo.
4 years. And that, think about it for a second. If it's not mentioned, whatever it is, the term, you go to the gap fillers. 4-year statute of limitations, followed by a 1-year statute of limitations in the second writing. What do you do when you have different terms? They knock each other out. There are 3 approaches to different terms under 2207. For the purposes of the exam, use the one that most courts use, which is the knockout rule. They knock each other out, which means then you're left with gap filler, which is how many years?
4 years.
B. See how it works. So once again, if you aren't comfortable with 2207, and no one in the world is really, because it's such a, they call it a murky bit of prose for a reason. But use the steps I just gave you and think about those groupings that I gave you, and that's going to help you quite a bit.
So what knocked out each other out? The inclusion of the statute of limitations clause and then the absence of it? 4
years versus 1 year, because 4 years is the implied statute of limitations in the purchase order. 1 year is the stated statute of limitations in the acknowledgement. They knock each other out, and when the terms knock each other out, where do you go?
Yeah,
gap fillers.
Okay.
Yeah, 4 years. Any other questions?
Why was the 4 years implied? Because
It's implied because it was silent, and you always go to the gap fillers. It's just like if this had been about a disclaimer of warranties. If the original offer had said nothing about implied warranties, you're still going to imply a warranty of merchantability and fitness for a particular purpose. They come along automatically, right?
But that's only because they're both merchants.
Yeah, right, correct. If they're not both merchants, it's a different story altogether. Okay, any other questions on number 2? If not, then number 3. coming up on 3 minutes, and tomorrow I don't know if yours is registering, because you clicked there, but it didn't change. Anybody else think you didn't? Yeah. Yeah. They turn off to conserve energy. So always make sure, clicking again, see, there we go. Okay. All right, let's see how we did here. Okay, not so bad on this one, but not perfect. I don't know why it's not. Well, anyway, D is the right answer. It should highlight better, but it didn't. Let's talk about why D is the right answer. And by the way, I know you haven't studied all these subjects yet. So if you don't know the exact rule, that's not as significant today as technique and approach to the subjects. And one of the things that I really want to focus you on is approach to the subjects. So question is a con law question. Powers and rights, con law 1 versus con law 2. We're talking about privileges and immunities clause, so we're into the rights area. It does matter knowing your sections, your constitutional sections when it comes to con law, and cases are absolutely essential. And you should have seen several cases peeking through in this fact pattern, because I actually combined several different cases. So we've got Fisher, who is a commercial Fisher person who is required to purchase a license. What should be significant about this question? First of all, under privileges and immunities, remember that your privileges and immunities are not necessarily fundamental rights. They're important rights, but they aren't necessarily fundamental rights that you would talk about under equal protection, for example. What about the right to fish? The right to engage in a profession. Is that protected by the privileges and immunities clause? Sure it is. One of the most important cases in that area deals with the right to practice law and residency requirements that used to exist for practicing law in a particular state were found to violate the privileges and immunities clause. So some of you picked B. And yes, pursuit of a livelihood is an essential activities under the privileges and immunities clause. That's what the Virginia lawyer case said. But what do we know about Fisher? And what do we know about corporations for the purposes of the Article 4 privileges? Doesn't apply to corporations. So those of you who picked B went for the first half of the rule. And you didn't dig deep enough into the fact pattern and the exceptions, if you will, because corporations are not protected under the privileges and immunities clause. Now, C is there. It's really a remnant answer, which used to matter a lot. Doesn't matter so much now, but I use it as a platform, so I leave it in there. Once upon a time, I used to teach, and everybody used to teach, don't worry about the 14th Amendment privileges or immunities clause. And note, by the way, be specific about vocabulary. Article 4, Section 2 is privileges and immunities. 14th Amendment is privileges or immunities. They are different. And once upon a time, and I'll talk about the difference in a second, once upon a time, for a long time, for over 100 years, we used to teach that privileges or immunities had never been, the Supreme Court had never found a violation of the privileges or immunities clause. And that's true up until the Sands case a while back, which involved the right to travel. And there was denial of welfare benefits, and the court found that a residency requirement for denial of welfare benefits violated the privileges or immunities clause of the 14th Amendment. So we got a whole new ballgame now. You can't write out the 14th Amendment anymore. It is a possibility. What's the difference then between the two? With the privileges and immunities clause of Article 4, a state may not deny to citizens of another state the privileges and immunities it affords to its own citizens. So if Fisher had been an individual, then B would have been the right answer, because Fisher has to pay more money for that commercial fishing license than does a resident. Yes, sir?
I thought that didn't apply to recreational activities.
Yeah, that's right, it doesn't.
But if
It's a commercial. He's a commercial fisherman, though. He's commercial.
If he was.
Even if he's an
Just trying to find the
if he's an individual commercial fisherman, it still applies. If he's a recreational fisherman, it doesn't apply. Yeah, absolutely. Now, what about the 14th Amendment privileges or immunities clause? Under that particular clause, a state may not deny to its own citizens the privileges or immunities of national citizenship. So what are they? Well, right to vote, the right to the protection of the U.S. Marshal. I don't think they're going to test that one. Right to vote, yes, and right to travel. That's a big deal. Right to travel is huge in terms of the U.S. Supreme Court today. And be aware of those things that are important to the Supreme Court today. Right to travel is huge. And anything that the court spends a lot of time thinking about now. Waivers of sovereign immunity are also a big deal. So anything, 11th Amendment stuff, so anything that the Supreme Court thinks about a lot today is something they like to test. Remembering, of course, again, that you have to be an individual, not a corporation. And what about the market participant exception in respect to, right, market participant applies to Commerce Clause, yeah, right, but not to Article 4 privileges and immunities. So those little distinctions are the things that they like to test. Any other questions about this question? All right, number 4. And check your little whatever color lights. They're not blue lights anymore, whatever color they are. Green. Green, okay, thank you. Oops, sorry. All right, let's see how we did. Now, it's long. It's a property question. Everybody hates property. You're on the, It's actually one of the easiest questions. in the packet. And there's a reason why it's easy, which most of us didn't see. D, there, that one worked, is the right answer. Now, you could answer this question in one of two ways. You could know the rule, and anybody who was in my property class should have known the rule, but the statute tells you the answer. So let's look at that statute. Take a look. You go back to the fact pattern. If there is a statute in a question on the MBE portion of the exam, you must read it carefully and apply it, which is really the main point of this question. And property questions will give you a statute of limitations for the purposes of adverse possession, for example. We'll give you a statute in terms of recording, which we'll talk about a little bit later. So read your statute and apply it. And this statute gives you a 7-year statute of limitations. Okay, pretty straightforward. And then subpart 2. And if you didn't read subpart 2 carefully and underline, then you did yourself a huge disfavor because it gives you the rule. It says that the statute of limitations is told, which means it doesn't even start to run. And the owner must bring suit within the 7-year limitation period or within 10 years after the removal of a disability in existence at the time of the cause of action accrues, whichever is longer. Even if the statute doesn't tell you, the disability must be in existence at the time that the statute starts to run. Otherwise, you disregard it. And now we look at the fact pattern, and we've got year 1 when possessor enters and year 3 when owner is adjudicated incompetent. So do we care that owner was adjudicated incompetent? No, we don't. The rule tells us that we don't care, and the statute tells us that we don't care. So take those gifts. If they give you hints, read carefully. Once again, that's really the purpose of this question, is to show you how important it is to read the question carefully, which takes us down to D. Now notice, by the way, that the rule isn't stated in D, but it's certainly implied in D, because if possessor enters in year 1, that's before the disability arose. You cannot count on the right answer having a neat statement of the rule. In fact, sometimes your distractor will have what looks like a really lovely statement of a rule, but it's the wrong rule. So make sure that you read carefully. Yes, sir?
So do they do things like that with just the nomenclature, like the cause of action accrues? So that means when he entered the land, that's when the cause of action accrued, not when he brought the cause of action.
Correct.
Okay.
Yeah. Correct.
So they do little things
Yes,
like
that's
that.
correct. Because when you bring, your cause of action may have accrued a long time before, and statute of limitations might have run out. Accrue means when it when it ripened, yeah. Okay, other questions? Yeah, vocab, words are so important. If you don't like to pay attention to words, you must learn how to pay attention to words for the purposes of this exam. Teeny little things like that can make the difference between getting the question right and getting it wrong. And if you talk to your friends, every time there's somebody out there that gets the 135.5, heartbreaking. What do you need to pass? 136 combined. Do you know how that works, by the way? I don't want to spend a lot of time talking about it, but you got 2 parts of the exam. MBE, Florida. Well, you take the Florida first, actually. Each part is worth 200 points maximum. And if you are a first-time taker, they average those 2 together, or if you're retaking and you take both parts, they average them together, and you get a combined score. And your combined score has to be at least 136. If you get that 135.5, they do not average up. So, and no, you know, it's really sad, but it's true. And every point counts. If you get a 140 on one part and a 135 on the other, okay, your average exceeds 136. Now, on the MBE portion, 200 questions, each question worth 1 point. You get a raw score, which is the total number you get right. And then you get a scaled score. they scale the score by doing one of two things. Well, a combination of both, actually. Some questions are what they call experimental questions. They try them out to see how they fly, and they don't count. And so they scale out a question by giving everybody credit for it. That's an additional point that you get, even if you got, well, if you got the right answer to begin with, you don't get an extra point. But if you got the wrong answer, you get an extra point. And sometimes they also scale out questions that don't perform well. It can happen, and I'm sure you've seen it on a law school exam. Sometimes the professor writes a question that doesn't work for whatever reason. So you scale it out by, once again, giving everybody credit for an answer, occasionally by giving people credit for A and C or something like that. So your scaled score is what matters for passing. And if you do extremely well, if you're the person who gets the 170 raw, then you're not going to get a lot more scale points because you got so many right to begin with. If you're the person who got a 115 raw, you get more scaled points. And they're going to scale somewhere between 10 and 20 points max. If you get below 100, they automatically scale you up to 100. They'll give you that, but you're not passing. Okay? Now, the Florida portion goes the other direction, and it makes people crazy. But here's how it works. You have 3 essays, each worth 100 points, and 100 multiple choice questions, but they throw out 10, in quotation marks, experimental questions. So you actually have just 90 multiple choice questions worth 1 point each. So that's 390 points. But they have to squeeze it down to 200. And this is the part, yeah, I got to stay out of the line there. This is the part that makes people crazy. Because you could have a 165 raw in Florida scale down to 132 or something like that. Yeah, because you start out with 390 points, and they have to squeeze it down to 200. And you could have 2 people each scoring 165 on Florida and ending up with a scaled score that's different. Because they have to take the 6 components, 3 essays, and 3 multiple choice. And as best they can, with a lot of, it's a funky process. I'm going to tell you, it's a very funky process. But they're trying to even them out so that each of the 6 components is worth the same, even though they don't start out with the same point value. And so they weight. And remember, your essay is worth a total of 100. Your multiple choice, each component worth 30 approximately. So they have to scale them to even them out, and they scale all of that down to 200 points. And then they take the 2 scaled scores and they average them. One question like this one, with the answer given in the question, can make the difference between passing and failing. So, moral to the story, read carefully. Okay, any other questions on number 4? If not, number 5.
One quick
Yes,
question.
Tamara.
I think with this question, I struggled with the rule as to whether the possessor came on before disability or after the disability, because I think there are 2 different rules.
Well, right. Once again, even if the statute hadn't told you, the rule is very clear. You disregard any disability that arises after the adverse possessor enters. Period. End of story.
Common sense, like they don't have knowledge of
Yeah.
it. Right.
Well, absolutely.
That
That
makes
is
sense.
true. That is absolutely correct. The disability has to be in existence because otherwise you can't be charged with it.
Is the
Right,
common
exactly.
law that it tolls during the disability of the owner though? Is that the common law?
Only if the disability exists before the possessor enters.
Think about
That's
it,
the
if you're
common
there,
law?
That's the common law rule.
if you're there 2 years and you're aware of it, then you become disabled.
Yeah.
You didn't do anything 2 years beforehand.
And,
So that's your
and
fault.
this statute in this question just embodies the common law rule. I gave it to you there just to give you a little gift, if you will, and also to illustrate how important it is to read carefully.
And in that rule, if the disability existed before the possessor came, whether the possessor knew about it or not wouldn't matter.
Well, that's true. You do not have to have actual knowledge. It just has to be in existence. But you're not going to punish an adverse possessor who, if the disability arises afterwards. Okay? Okay, number 5. All right, see how quickly you answered this one. It's evident, it's short. I'll see. And most of us got it right. Sometimes this works and sometimes it doesn't, but B is the right answer. I don't know why. So let's think about a couple of things with evidence. Actually, before we talk about evidence per se, so look at the fact pattern here. What is the key in the fact pattern here? Because he, what word? Always, yeah, right? That's what makes it habit. Now, you're,
Several years.
well, yeah, it's true, but it's, he always does it all. You know, you've had 2.5, 3 years of law school. The law's not black and white, it's shades of gray. And so you'll be taught that you should avoid absolutes in your answer choices. But sometimes it's the right answer. And when it comes to habit, you need that absolute. He always does it. He never does it. Every day he does the same thing. And of course, that absolute is what makes the evidence here habit evidence, not mere character evidence, which makes B the right answer. Now, I want you to think about evidence, an approach to evidence that may be helpful, because evidence can be hard. Even though the questions are short, it can be tricky. And I want you to do a couple of things. First of all, assume that it's something other than hearsay. Now, you spend most of your time in your law school evidence class talking about hearsay, right? And you're going to spend a lot of your time preparing for the exam studying about hearsay. But hearsay is rarely the right answer, because in real life, if you can't get the evidence in one way, you can get it in another. That's what a good trial attorney does. So as you evaluate a question, if you're even thinking hearsay, think of all the other things: impeachment, ownership or control, elements of a cause of action, all the other things that the evidence could be used for before you gravitate to hearsay. Now, in addition, I'm going to suggest an approach that some evidence professors use. I don't know if any of yours did. It's an older approach, but I think it's great for the bar exam. It's a 3-step process, and it helps you avoid going to the rule right away, because it's a lot of rules, and sometimes it's hard to figure out which rule applies. So the first thing you do is you determine what kind of evidence you have, which is usually pretty easy. Is it real evidence, the murder weapon? Or is it documentary evidence, a contract? Or is it testimonial evidence? And along with that, sometimes, especially if it's real evidence, you may have some evidentiary chain of custody issues as well. But really ask yourself what kind of evidence it is and be as specific as possible. You may also have to deal with some privileges at that point, which we'll discuss a little bit later. Second step is the key step. If you get this step right, you will get the right answer. And you ask yourself, what is the evidence being offered for? Now, be as specific as possible. What kind of trial do we have? Is it civil? Is it criminal? Who's offering the evidence? Is it being offered by plaintiff or defendant, or prosecution or defense? Is it being offered on direct or on cross? And importantly again, why? Don't assume that it's being offered for the truth of the matter asserted. Assume it's being offered for something else. And by the time you go through those steps, you will have led yourself to the right rule, which is the third step. Is the evidence admissible, or is it inadmissible? And if you take the time to ask those questions, you're going to get the right answer. And remember that most evidence questions are very short. The last person to answer answered at 1 minute and 33 seconds. Most of you answered faster than that. So you have the time with an evidence question to go through those steps. And I promise you, if you really parse that second phase, which is, again, what's the evidence being offered for, you can lead yourself to the right rule and therefore the right answer in most of the questions. Any questions at this point about evidence? All right, number 6. All right. See how we did on this one? Pretty good, because B is the right answer. Hang on one second. You can take... That's our winner. If you want to take some pizza, I can take some. And I'll clean up the rest. So, this particular question, of course, deals with negligence, but I like to put it right up against the other question, the previous one, number 5, because in number 5, the absolute was the key to the right answer. But in this question, the absolutes make the wrong answer, right? Because we're talking about our reasonable person. And the reasonable person has to be judged by the person in the context of what's happening. So when we think about, and by the way, this is another case I purloined from Prosser, but I changed the facts a little bit. You may remember a case of a guy who was driving on a dark road at night, came over a hill, and he ran into a cow. Now, that was a little bloody gory. He killed the cow. It was a black cow. He left the cow in the middle of the road and kept driving. And then another driver came over the hill and couldn't stop and didn't see the cow and plowed into the cow, and it caused injuries. So I kind of changed it to take the blood and gore out, but it's the same concept. Should have left it. Yeah, should have left it. I know. Yeah. Yeah. A couple of things going on, though, in the question. First of all, the absolutes in the answer choice. Because sometimes you should do something and sometimes you shouldn't. And the example I always use is if I go out, my car's out in the parking lot, and I leave here, and I'm in a hurry, we're all in a hurry to get out of here, and I'm walking out with this water bottle. I stick it on the roof while I'm putting stuff into the hatch, and I forget it's there. I start driving out of the parking lot, and I'm driving out of the parking lot, and Tamara's going, should I stop? Probably I should, right? Because if it falls off, it might fall in somebody else's car, ding it or damage the paint. And I haven't gotten very far, and I can stop, right? But if I make it all the way out onto the Palmetto, and I'm driving on the Palmetto going east so I can go home, and then Tamara's driving along beside me, and she's going like this, am I going to stop? No way. No way. Not on the Palmetto. So the reasonable person does what's reasonable in the circumstance, and the always in the answer choices here make 2 of the answer choices incorrect. Reasonable driver, if you look at A, would always stop? No. And C, a reasonable driver wouldn't stop? No. And no one picked D, and that's the complication in the question, which didn't distract anybody, and that's great. Because you actually have 2 duties in this question. Remember I said if you have a negligence question, first thing to do is to focus in on duty, which of course is the first thing that you study in torts when you study negligence. Duty number 1 is to tie the suitcases on properly, which it appears the driver did. So duty number 1 was met. We don't care about foreseeability because the duty was met. But duty number 2 arose when the suitcases fell on the street or the highway. And that's what the court talked about in the cow case, because the guy didn't have a duty necessarily to avoid the cow because he didn't know it was there, the first driver. He didn't know it was there. He came over a hill. The cow was black. There were no lights. He couldn't see the cow. But leaving the carcass in the road was the problem.
If the fact said that the driver was unaware that the suitcase fell,
oh, good. Oh, okay, good. Absolutely. If you don't know that the suitcase has fallen and you properly tied them on in the first place. So let's take this water bottle. Although I placed it up there. I'm trying to think of how. Suppose I put it in the hatch and I shut the hatch. But then it opens without my knowledge and without my fault. And the water bottle falls out. Then you might not have a duty. That's correct. So yeah, pay attention to the facts. Now, one final comment on torts. Do not think that, even though I have 2 easy torts questions here, that torts is easy. Some of you, if you took AOL or ALS, whatever it was called, you'll know that already. Don't be lulled into complacency when it comes to torts. It is a very deceptive subject.
Intentionally.
Intentionally. There you go. All right.
Can we go on that note?
Purpose or knowledge.
Can we go on?
I'm sorry?
Can we go on that note?
Can
just
you?
kidding.
Yeah. You can go, but we're not quite done. Number 7. Okay. Let's see how we did on this one. It's a contracts question. Some of you answered very quickly, but contracts usually takes a while, and not bad. D is the right answer. Now, we've got a requirements contract in this question, which is something they like to test on both parts of the exam. That's why I included this question. Also, don't get the idea that they test just Article 2, even though I have 2 Article 2 questions here. Make sure that you study the common law too. But we've got a requirements contract. And of course, requirements contract, in a requirements contract, your buyer cannot demand an amount that is unreasonably disproportionate to stated estimates. Demanding unreasonably disproportionate amounts has been construed, and you may have had the case or cases in your contracts class, to requests for more. There's a different rule if the buyer doesn't ask for anything at all. And there's a fair amount of case law. There's the Empire Bakeries case, which has dealt with breadcrumbs, and there's another case involving electrical cars, I think. If the buyer asks for nothing at all, the courts have said that's not an unreasonably disproportionate demand, because demand means ask for more. See how carefully, again, words have to be construed. If the buyer takes nothing at all, then you have to ask why did the buyer take nothing. If the buyer took nothing because the buyer is going out of business, there's no breach of contract. If the buyer took nothing because the buyer is just trying to save money, you have a breach of contract. Now, some of you may be thinking, well, what's the difference, right? If you're going out of business, you want to save money, but that's the rule. And here, if buyer declines to order because buyer closed the department store, the buyer has no need, and therefore there's no breach.
When I read closed his department store, I thought he was trying to, like, that's all that he just operated from August to October, the end of October, and he closed the store, but the contract went through December.
Right. But if that's the point.
It wouldn't matter.
Yeah, that's the point. If he's no longer in business, that's the breadcrumbs case.
Yeah.
Then there's no breach. That's the difference.
But wouldn't there not be, in the specific verbiage, there wouldn't be a breach even if he wanted to save money if he didn't need anymore, even if it was still open and he had enough bags. It's if he went somewhere else to get them.
Well, absolutely. If it's an exclusive and an outputs or a requirements contract is likely to be exclusive, but doesn't have to be. So always look in the facts for that particular point. I mean, I'm sorry.
That's the way I read it.
Yeah. It is possible to have a requirement. I'm going to take, my requirements from you, but it doesn't preclude me from buying from somebody else too. Look for that word exclusive on that particular point. There's actually case law on that point as well.
Would this be a remedy in equity or law?
This is going to be a remedy at law.
So
Damage, money damages. Good point, though. When you have a contracts question, whether it is multiple choice or essay, that's one place where remedy matters a whole lot. And I don't have any remedies questions in here, but when we get to the contracts question, essay question, we'll talk about remedies. Remedies don't matter so much in torts, and they really don't show up pretty much anyplace else. But contracts, know your remedies, both common law and Article 2. Okay, any other questions on number 7? Then let's do number 8. Do we all think we rung in on this one? We're missing somebody. Okay, always check your little lights. Oh, there we go. All right, let's see how we did. Pretty good. Not perfect, but pretty good. Now, Threshold questions. They do like to test threshold questions on the MBE portion of the exam, and you would be surprised at how often they throw threshold questions into essays. Standing, mootness, ripeness, and questions of that type, plus jurisdictional questions. They like to sneak in little things like jurisdiction or threshold at the beginning of a Florida con law question. So always, and not just Florida con law, the contracts question that Gina showed me from February of last year had a venue issue, which is considered to be Florida con law. So make sure that you look for those types of issues. Now, there is a clue buried in this fact pattern that makes the question very easy. What's the clue?
I saw two of them.
Okay.
The class action and also August and May.
Okay, good. And the class action, if it's a class action, then, and that's Roe versus Wade, there's still a live controversy as long as some member of the class is entitled to bring the lawsuit, even if you're named plaintiff. And that was the case in Roe versus Wade. The named plaintiff was no longer pregnant by the time the case reached the court, but there were other members who were still in the class. Question?
My question was that Roe versus Wade, the way they've been teaching it wasn't the class action reason, but was like
Capable of repetition,
Yeah,
yet evading
I was-
review. Yes,
Yeah.
but factually, yeah, it comes out in very much the same place, and that rule was stated in Roe versus Wade, capable of repetition, yet evading review. But the fact of the matter was that the woman who was the named plaintiff, the Roe in that case, was actually no longer plaintiff at the time, pregnant because of the time passage.
So we're just supposed to assume that there's people still in that class.
Yeah, because we got somebody who's how many of you are out of state?
We put it August and May.
Augest to May, yeah.
No, I understand
Yeah.
that, but I'm saying, what if everyone was in his position where
Yes.
they've all now.
But there are still students out there,
Potential for
potential,
repetition.
well,
That's
there,
what I'm saying,
yeah.
we just, I mean,
Oh,
I
okay.
guess, I get that.
Right.
We're just supposed to apply that there's always gonna be people joining
Sure,
in this class.
because you're always going to have more students coming along who are going to be from out of state. You know, it's there, and it keeps, and you can add in, of course, the capable of repetition yet evading review. Both are applicable to this particular fact pattern. Any other questions about number 8? All right, number 9. We're getting near the end, folks.
Some classes can take 3 minutes, some takes 2 weeks.
That's exactly right. That's the whole point. Yep, okay. All right, let's see how we did on this one. What'd we miss? To have standing, you have to be a what kind of guest? Overnight guest. Oh, we're getting tired. Yeah. The rule is a pretty straightforward one. When it comes to Crim Pro, first of all, I'd have just the one Crim Pro question because you're not going to have as many Crim Pro questions on the exam. Remember, Crim Pro and Crim Law are considered one subject, so you're going to have approximately 30 total of them, and a little bit less than half likely to be Crim Pro. Crim Pro, very case-oriented, and I'm not remembering the name of the case at the moment, but there's a very clear case from someplace in the Midwest, Wisconsin, Michigan, some Midwestern state, overnight guests. And our guest here was just a day visitor. So very simple. So,
But I'm kind of confused because officer arrested guest.
yeah,
So he was
right.
guest is suppressing marijuana.
Right, no, a guest is suppressing to have standing to object to a search of the premises, which is what guest is, because the bags were found on the premises, not on guest person.
Right.
Different issue. Okay, if it's found on the person, whole different ballgame.
Next time.
You got it. Yeah. So if it's a search of the premises, you have to have standing to object to it, the premises, and you have to be an overnight guest. So that's just careful reading on that one. And just a hint as we finish up, because we have just 3 more questions. You're going to get tired. And when you get tired, you don't always pay close enough attention to the fact pattern. So be aware of it and understand what you have to do personally. And it's going to depend on the person. I don't sit well for long periods of time. I get drowsy. My back starts to hurt. So I made myself get up, which sounds nuts, I know, in the exam, but it actually really mattered a lot. When I would get up every hour, I'd just walk around the room, get a drink of water, whatever. Got the blood flowing again, got to shake out all of the whatever. Understand what you need to do if you're getting fatigued. It's really important. So, with that in mind, number 10. Okay, we're at the 3-minute mark. Anybody else want to ring in? It's property, it's long. All right, let's see what we have. Pretty good. Not perfect, but pretty good. It's a recording question. And the first thing you have to do with a recording question, of course, is identify the type of recording statute that you have. Now, just a heads up, they love to test recording on the MBE, so you will have a handful of questions on the MBE dealing with recording statutes. And they will give you the statute because, of course, there's no MBE rule in terms of the type of recording statute. For Florida purposes, they also love to test recording. It shows up all the time. Florida is a notice jurisdiction. So make a little note there. I know you haven't studied Florida stuff. You may have covered it in your property class in law school. So first thing we have to do is determine the type of recording statute. And they're likely, occasionally they'll give you a race statute. It's easy, so just whoever gets to the courthouse first. The real difficulties lie in notice versus race notice. Now, what you're going to do is read the statute looking for evidence of how many people have to record. If the first purchaser has to record to give notice to the second purchaser, it's going to be a notice statute. And so you're likely going to see the verb record, recorded, records, some form of that verb just once for a notice statute, because that tells you that the first person has to record to give notice to a subsequent person. If it's a race notice statute, 2 people have to record. The first person to give notice to the second person, and the second person is also required to record. So you're going to see that verb twice. Records, recorded, recording. You're likely, but not always, going to see a first, which you have here too. But don't rely solely on first, duly recorded, because there's more to it. So in this statute, it says, first of all, that a conveyance is void against a subsequent purchaser, whose conveyance is first duly recorded. That first duly recorded refers to the subsequent purchaser. And then it says, so the subsequent purchaser has to record. And then it says, unless the conveyance shall have been duly recorded prior. That means the first purchaser has to record. 2 people have to record. It's a race notice statute. So first thing you do is figure out whether it's notice or race notice. Yes, sir?
The reason I didn't pick the right answer was the way that the D was phrased. It seemed more like possession was the requirement, because took the parcel, the way that's phrased just reads as possession.
You possess the parcel first also, though.
Right.
Right, but since notice was the requirement.
Oh, well, we're going to get there. We'll get. I'll explain why. But first step is, what kind of statute do I have? Then you ask yourself a series of questions. If it's a notice statute, you ask 3 questions. If it's a race notice statute, you ask the first 3 questions plus a 4th. And the 4th is what makes the difference in this question. So let's take those questions in order. The first is you have to identify who is the subsequent purchaser. You're going to have 2 claimants, and the subsequent purchaser is the person who took later in time, which in this case is going to be vendee, because purchaser took in year 1, and then vendee took in year 8. So vendee is your subsequent purchaser. Second question is, did that person pay value without notice? And in this case, yes, vendee paid value. And then paid value, then notice is your third question. I'm getting tired too. So second question, did that person pay value? Vendee did. Now we talk about notice. We have 3 kinds of notice: actual, record or constructive, and inquiry. Actual notice is you actually see the deed. Well, vendee didn't actually see the deed. And inquiry, is there something funky about the land? Is somebody living there? Do you see laundry hanging in the backyard or something like that? No inquiry notice here, though the third is record or constructive. And the question is, did purchaser record at the right time. And yes, purchaser recorded at the right time here because purchaser recorded when purchaser bought the property in year 1, which provides record notice to vendee. But there's a fourth requirement as well, because even if vendee didn't have notice in this case, it's a race notice statute, vendee has to record. Did vendee record here? Nope, vendee didn't record. So who wins? Vendee is not protected under the recording statute. Number 1, vendee had notice, constructive notice, and number 2, vendee didn't record. When your subsequent purchaser is not protected by the recording statute, what rule do you use? First in time, first in right. Who's first in time here? Purchaser. That's why D is the right answer, because purchaser is first in time, first in right. If your subsequent purchaser is not protected by the recording statute, then the first person wins, period. The first person does not have to be qualified under the recording statute. Just has to be first in time. So make sure you review recording for both parts of the exam. All right, we are getting into the home stretch. Just 2 more questions. So number 11. Okay, let's see how we did on number 11. Interesting. We flipped coins, didn't we? Okay, now, marital privileges. There's marital communications and there is spousal immunity, and they are different, and that's the type of thing they love to test. Plus, I won't talk about it now, Florida's rule is different from the federal rule, so you got to keep your head straight. So let's start with marital communications. Marital communications protects confidential communications made during the marriage, right? And who owns the marital communications privilege under the federal rules? Both spouses. So either one can object under the federal rules. Spousal immunity. The parties have to be married when? When the testimony is elicited. And who owns, under the federal rules, who owns spousal immunity? The witness spouse. Now, who wants to testify here? The wife does. And so if she chooses, now I'm lost myself. It's protected by marital communications, isn't it? Because the husband can object. She is the only one who could object in terms of spousal immunity because she's the witness spouse, and she's waiving it. right? So she has waived spousal immunity. But even if she waives marital communications, he can still raise it because she said it over breakfast when they were alone, and so it is privilege. Is it, by the way, an admission? You bet it is. It's a mission of a party opponent, but it's privilege. And that's the other thing to understand about these questions. The more difficult evidence questions will have several layers. You have to know not only what kind of evidence it is, but also how it's affected by privilege. Make sure you do study your privileges because they do get tested, and as you're going to see, they are different to a certain extent in Florida. Any questions on that one? Number 12, bringing up the rear. Go ahead and put your name on here, and clip that. Yeah, clip that together so that I don't forget. All right, we're there. All right, let's see how we did. Decent, not perfect, but decent. Now, I put this question last on purpose because you're tired and you're not paying attention, and so you go for the distractor. What is the call of the question? Activist has been charged with what? Attempted murder. And all attempts require what kind of intent? Specific intent. Specific intent. And so A is right. He did not intend to kill victim. If you look at C, it looks really juicy because, yeah, he probably was reckless. But he didn't kill her, and so he's not charged with murder. The other thing to remember when it comes to criminal law, in your criminal law classes, unless you have me for criminal law, you probably spent most of your time on the MPC. And the examiners know it, and so they test the common law. That's why I spent so much time on common law in my criminal law class. They love to test the common law on the MBE portion of the exam. So if you did not focus, number one, on common law in your criminal law class, make sure you do. And number two, if, as is very likely, another reason why I kind of throw it in my class, if you did not spend time on theft crimes in your criminal law class, make sure you review theft crimes because they love to test theft crimes. And, of course, there are different rules for Florida. Another day. So that's it for today. Just a couple of things, and I'll send you out the door. Please turn off your clickers and kind of put them in the front. Here are the answers to these questions. We will email you the text that was missing for multiple choice questions. If you have any questions, if they are substantive questions or they're study technique questions, feel absolutely free to shoot me an email. And if you want to start sending me essays anytime that you want, please feel free. Next week, remember again, is Professor Martin, followed by the following Friday by Judge Shepard doing Florida Con Law. So we've got some really important lectures coming up. That's it for today.